Yeah, let's tweak this now and look at what perhaps some of us don't know and what we should be expecting, because, you know, the elections are over in terms of, I mean, I'm referring to the presidential election now, and we're seeing a declaration of the winner, Bola Tinubu of the APC, and Kashim Shettima, now the vice president-elect. So what do we expect from now, especially for those who are aggrieved about the process, the conduct of the election and the outcome? They've gone to court. Several political parties are challenging the outcome. But, I mean, we're hearing stories of the constitution of the Presidential Election Tribunal. We are hoping that there will be an official release and statement on those who will make up the panel, the tribunal panel, for that presidential election petition. What days should they file? If they file, how long will this take? When should we be able to get a judgment? If there is a judgment, can they go to a Supreme Court? If they go to Supreme Court, how many days are allowed? When can we finally get a total and final determination at the court on this matter? Let's get some legal perspective onto this. I'm being joined by a very senior lawyer, senior advocate of Nigeria, Kayode Adeoluola. Thank you so much, Leonard Sik, for joining us again. And indeed, we are delighted that you can be able to join us to shed light on this. So I tried to paint a picture.
Thank you for having me.
Thank you so much. It's good to see you again. I tried to paint a picture and I drew a timeline of the litigation time frame, and if we can put it on the screen so our viewers can get a sense of what we mean. And correct me if I'm wrong in my diagram, let us see. But this is what I interpreted the process to be. So there is the instant of the day of election, which I assume that is the day on which, by law, the petitioner time start to count. Is that right, Mr. Adeoluola? So the days that they have before the day they file, and of course, how many days the tribunal has to make its position and give its judgment, and before the window. So please go ahead and help us out with the explanation on this. Let us
just let you know that the tribunal. Yes, can you hear me?
Yeah, I can hear you now. Please go ahead.
Can you hear me?
Yes, I can hear you. Please go ahead.
Right. So, as I was saying, that the tribunal is made up of judges, made up of judges of the High Court, or cadis of the Sharia Court of Appeal, judges of the customary courts, or a chief magistrate. And each state has the tribunal for the National Assembly or the State House of Assembly. And for the presidential election, which I'm sure is what you're most concerned about, the court jurisdiction to take that election petition for the presidential election. 21 days is given to the petitioner from the date the election result is declared, that is, when the winner is announced. So they have 21 days within which to file their petition. That's correct. And once they have filed the petition, they must serve the petition on the respondent personally. That could take a few days. Sometimes it may require the petitioner to file an application for substituted service. If, for example, they are unable to reach the respondents personally, they could bring an application for substituted service. That could take a few days. And once the petition has been served on the respondent, well, the president-elect, he's got also 21 days to respond. Once he has responded by filing his own reply, which is by way of a defense, and he serves it on the petitioner then has 5 days within which to file a further reply if new facts have been raised by the respondent in his reply. Once that has been done, it then becomes the responsibility of the petitioner to file the TF form seeking the order of the election tribunal for pre-hearing sessions. Of course, if it fails to do that, then the respondent is allowed to do that just to quicken the pace. Once that has been done, the tribunal then sits at a pre-hearing session rather, where they take different issues. How long is this each witness going to take? The documents that need no argument about. They also agree on the order in which witnesses will be taken, and various things such as that, to ensure that there is a smooth sail of the hearing of the petition. Don't forget, the tribunal, or the Court of Appeal as it is in this case, has 180 days within which to deliver its judgment. Once the pre-hearing session has been taken, then the parties are ready to go on to trial. But don't forget also that once the petition is concluded, evidence taken, documents tendered, then the tribunal gives judgment. If the tribunal then gives judgment and one party or the other is unhappy, he can then proceed to the Supreme Court as it is in this case, the case of the presidential election. And curiously, the Supreme Court has only 60 days within which to deliver its judgment from the date the decision is given at the lower courts. And so those are the timelines.
Fantastic.
Sure.
It does look like, Leonard Sick, I'm very right with the picture that we painted there, which basically helped in when you are describing the journey from the day of the declaration of the winner of the election to the day of filing, 180 days to determine the judgment by the tribunal. They have a 14 days appeal window, and the Supreme Court, if there is an appeal to the Supreme Court, because now we understand, a lot of people perhaps may not know that the presidential election petition emanates or begins at the appeal court. So that is the court of first instance in this tribunal, isn't it? Am I right?
That's correct.
All right. So the Supreme Court has 60 days.
The Court of Appeal has the, yes.
Yeah, go ahead, sir.
Yes, the Court of Appeal has the original jurisdiction to take the presidential election petitions.
Yeah. So when
and I must add also in a situ, and I must also add, if you like, just 1 minute, if there are if there's more than one petition, if there's more than one petition regarding the outcome of the same election, such as the one we have at the election, we have a petition from the first runner-up, and we have another petition from the second runner-up. Those two petitions can be taken and can be consolidated and taken together by the Court of Appeal.
So there's so much more to talk about. So if anyone is aggrieved from the position of the election petition, Presidential Election Petition Tribunal, they can go to the Supreme Court. 60 days is when the Supreme Court has to determine and come out with its position and judgment on that case. Mr. Kayode Adeluola, Senior Advocate of Nigeria, has been speaking with us on the program, and we've been looking at the processes and the proceedings in a presidential election petition tribunal, and of which one that has since commenced the process, because we've seen different parties have gone to court challenging the emergence of Bola Tinubu as the winner of the presidential election of 2023. So what should we be expecting as citizens of Nigeria? The Nigerian Bar Association has sought that the Court of Appeal, the Presidential Election Petition Tribunal, should televise or allow for the live telecast of the process and the proceedings in the court. Would that be allowed? If that happens, how much of transparency can we see in the process? Let's get back to the senior lawyer to give us some more insight into this. So before we went on that break, I was asking you, 60 days is what the Supreme Court has, the window for which to determine. So in all of these, it looks to me that we have nothing less than about 230 days. Is that right? If you look at if the calculation of all of these days,
let's put it.
Yeah.
Yes. Let's put it this way. We have 180 days for the Court of First Instance. Then we have 60 days for the Court of Appeal. That puts us 240 days. That's in total about 8 months, actually. So let's put it in perspective. We're talking about 8 months within which to have the petition taken and the appeal also concluded.
So if I look at my calendar and from what you just said, the election was determined in February. That's about 27th of February or thereabout. So March, April, May, June, July, August, September, and October. So sometimes around end of October, early November, we should be having a total, a tone of finality on the process. Is that right?
That is correct.
So in this sense,
that's correct.
For what we're saying so far now, how has the process been up until now? I'd like to get your view on what has gone wrong. Is there any mistake in the process? Is there anything that has been missing so far? Or has the process gone smooth based on what the law requires?
Well, to the best of my knowledge, the petitions have been served on the respondents. The president-elect has been served, INEC has also been served. And so what we expect now is for the respondents to serve their reply to the petition within 21 days. If they're able to do that within 21 days from the date they were served, not from the date the petitions were filed. 21 days from when they were served, I don't know when they were served, but 21 days from when they were served, they're expected to file their own reply. And once they have filed their reply, if the petitioners, that is Mr. Peter Obi or Alhaji Atiku, has any reason to file a further reply, they have 5 days within which to do that. And that is after that, then the pre-session commences. The pre-hearing sessions will then commence. Well, going to what you asked regarding live coverage of the hearing, that would be quite interesting, but I think would require well, so how do I put it? The direction of the President of the Court of Appeal to determine whether that should be done or not. Ordinarily, all that the rules require is that the hearing should be done in public, and public should be where people can have access. But in this situation we're talking about, for the benefit of everyone who wants to witness it, I think a recording may be made and then played on your stations later on in the evening. That's what I think may happen if we actually want that to go on.
So I sense what the Constitution is, a constitutional provision, isn't it? That the court, I mean, the provision that court proceedings are supposed to be public, but there are no distinct position of the law on whether a proceeding can be televised, because that's going to be in the remit of the court, isn't it? Court is now going to determine whether or not it will allow. But what we have seen in the past, Lionel Sikh, is that court as soon as the judges walk into walk into the courtroom, television cameras are not allowed You can take pictures before and after, but as soon as the judges walk into the courtroom, you then are not allowed. But what if we remember what happened in the Oputa panel? That was televised. It was allowed. Television cameras picked whatever the Justice Oputa led panel, who was the proceedings at the time. But in this sense, what does the rule of the Court of Appeal say in this regard?
That's why the rules just require that hearings should be done in open court and accessible to the public. But then again, as I said, the President of the Court of Appeal can give practice in which these procedures can be televised, I believe, because if you recall, during the COVID period, we had situations where hearing was done in some courts via Zoom. And so if that was allowed, it is not unlikely that this can also be accommodated in the hearing of the election petitions. That's my view.
So what does it entail then? Because the identity, it does look like, because in other climes, take for example, we've seen proceedings in like manner in Kenya. We saw the proceedings on television, and we saw a similar scenario playing out in South Africa. Why is it that televising a court process or proceeding is not a commonplace?
Well, Sheila, let me put it this way. Things just have to be tested to determine whether they are allowed or not. The rules of court do not specifically say that court proceedings should be held in open court or televised. But then again, practice directions can allow for some of these things to be accommodated. It's not unlikely that we have a situation where it will become a standing rule or part of our rules of court, allowing proceedings to be televised. For example, people who are incarcerated or in custody should be able to give their testimony from the prison if it becomes necessary. Otherwise, you could also find situations where witnesses are unable to come to court, and their testimony becomes very crucial to the determination of the matter. An election petition is not one that involves children who are usually shielded from public view. It's not one that requires that there should be some secrecy about it. So really and truly, in the modernity that we are facing and technological age that we are also facing, I do not, in my candid opinion, see anything wrong with the practice direction saying that the election petition, the election hearing should be done on television or televised in such a way that those who are unable to attend court can then watch later on. Because don't forget, the lawyers who are going to be appearing themselves are quite numerous, such that by the time they all take their seats, members of the public and journalists may have only a few seats to occupy. So it might just be nice to see a situation where proper direction is given and things are done lawfully, not arbitrarily and without proper backing of the law.
Let's take a quick break, Lionel's sake. And when we come back, we'll be getting your final thought on how these proceedings should go, what are the standard practice procedure that we should be expecting, and whether or not Nigerians should be excited of what to expect in terms of transparency and in the manner in which the court will operate this time around. Is there anything different this time around compared to 2019, and what exactly has changed since then? So stay with me, everyone. We'll be right back in a moment.
Simply log on to channelstv.com, Click on podcast, select the program of your choice, and listen. Our podcast is available on Apple, Google, and Spotify. Tap the expertise you trust. Touch the stories that touch you. Anytime, anywhere.
So much, everyone, for staying with us on the program. Mr. Kayode Adeluola, Senior Advocate of Nigeria, is still with us on the program tonight. So let's look at it. What do you think should be exciting Nigerians about this process? For those who are, I know there are supporters of one side and there are other supporters of the other side. What exactly should we be anticipating when the courtrooms are open for the arguments?
Let me put it this way. For members of the public, they want to hear the facts. They want to hear what happened. They want to know what witnesses are going to say. The witnesses already have filed the witness statements on oath. In other words, whatever the witnesses are coming to say will be written and signed by them and sworn to on oath and presented to the tribunal. In other words, these witnesses will not be required to give long testimony by way of examination in chief. But each one of them will be cross-examined by the lawyers of the opponent. Now that will be quite interesting because once you have the cross-examination, it's with the intent to destabilize the witness, to show that the witness is not credible, and to show that the evidence the witness has just given is not to be trusted and should not be regarded by the court. So you're going to find a situation where people are anxious about if there are certain facts. I'll give you an example. In the petition filed by Mr. Peter Obi, one of the grounds alleged is that Bola Ahmed Tinubu, the president-elect, had some involvement with narcotics in the United States of America. A lot of Nigerians are going to be excited about that. They want to listen to what the court will have to say about that. But then again, they must not forget that the court will then be required to determine what the law says concerning such a situation. That is what the court will then be determining at the end of the case in course of giving its judgment. But let us not be too anxious now, because the respondents are yet to file their reply. When they file their reply, we'll then have a balanced view. We'll see what the petition is, we'll see what the respondents have said concerning the petition, and that will form an interesting scenario, which, in the manner of speaking, I'll advise all Nigerians to get their popcorn and a drink, sit by and watch the proceedings.
That's going to be
because
interesting indeed.
A lot of things, of things that we do not, I think is going to be quite interesting. And I think this petition, these petitions will elicit more interest than the petitions we had ever before. A lot of people are going to want to see what the court is going to say about whether indeed and in truth there was rigging and there was no rigging, and whether those facts are going to be put before the tribunal. If the facts are put before the tribunal, what will the reply of the respondents say to demonstrate to us that indeed and in truth those things happened or they never did? So the witnesses are going to be very useful. The documents also are going to be very useful, and these are things that are going to be brought in the open. And so everyone has a responsibility as a Nigerian not to wait only for the final outcome.
Yeah. So I was going to ask quickly, because we're out of time now, are there scenarios where the candidates will be required to take the stand at some point in the proceeding? Do we have that kind of scenario playing out?
Well, it depends on the choice of the solicitors representing them. If they think that the evidence of the candidate is important, they may, but it's not likely. It's not likely because you then ask yourself, why would the candidate be put in the witness box?
Yeah, because I mean, when
he needs the evidence.
You were talking about one of the charges of one of the
various
political
stations. He was only at one polling station.
Yeah, the reason why I'm asking,
he needs the evidence of those who have documents, who can tender these documents.
All right. I mean, I was saying that
yes.
When you talked about some charges that didn't have to do with the election proper, the conduct of the election, that has to do with one of the candidates before the election, whether or not there will be a scenario to say take this stand on that kind of matter. That was why I'm asking. Could that kind of scenario play out?
Now, I'll just give you an answer, a quick answer to that. Whether a candidate was properly nominated or not is a documentary issue. His nomination form or his letter of withdrawal will suffice. And don't forget, INEC is also a party to the petition.
All right.
So they were also there at the hearing.
Thank you so much. I appreciate your time tonight. Lenny Sik, Senior Advocate of Nigeria, Kayode Adeluola, thank you so much for helping us out with some of these issues. Appreciate it.
Thank you very much.